Today in this video we will be discussing about the labor law. In the labor law we are going to talk about the Industrial Dispute Act 1947. There are so many acts are there in labor law. In this topic we are going to talk about the Industrial Dispute Act 1947. So it came into effect from 1/4/1947. This Industrial Dispute Act consists of 40 sections and 3 schedules. So we will be talking about, first of all, what is Industrial Dispute Act. Industry means anything which is an organization or an industry having the organized activities with skilled or non-skilled or technical laborers, and they will be producing they will manufacture certain production that is called industry. And the religious attitudes, even though there may be more persons employed, it is not considered as industry. And dispute means any dispute arising between employer. The dispute means some sort of the non-agreement or incoordination between one and another is called dispute. So the dispute between employer and employee, and employee. So with these three items of people, the dispute may arise. The dispute means that is a conflict of opinions. It may be the problem of wage settlement, it may be the promotion, it may be retrenchment, or it may be for demanding some extra wages, like that. So the dispute is defined as the conflict between employer and employer. Means the one employer of an industry may lure the other people to join in the another organization and disrupting the previous one. So those are all coming under dispute. That is between employer of one organization and the employer of another, and employer and employee, and in between the employees there may be problem or there may be disputes, conflict. Then the section 2 defines the industry. That is any organization engaged in business, trade, undertaking or manufacturing, calling of the employers, calling service employment, and like that the handicraft, these are all called industry. Industry means a well-defined business, trade, undertaking should be there, and also calling of employees, calling of service should be there. Then another thing involving capital and labor and skill. So that also the industry should involve capital by the employer or by the owner, and also labor and skill, and that cater to the human needs. So it should produce something and it should cater to the human needs. So that is called the well-defined case study is Bangalore Water Supply and Company, Bangalore Water Supply and Sewage Board versus Rajappa, 1978. And in this case, some of the employees were retrenched from the Bangalore Water Supply and Sewage Board, and they referred the case to the Industrial Dispute, and then it has been considered as, or it has been decided, or it has been ordered as the Bangalore Sewage Board, Bangalore Sewage Water Supply and Sewage Board as an industry, because it is on par with manufacture, and there is the involvement of skilled and unskilled capital and another thing involved. So it was considered as the industry, and then it was redefined in 1982 also. Then object of the act, why this Industrial Dispute Act has come. The Industrial Dispute Act has come into effect because to securing, preserving and encouraging harmony. So there should be a harmonious relationship between employer and employee. To preserve the harmony between employer and employee, this act has come. Then second, to investigate the disputes between employer and employer, employer and employee, employee and employee. And then to prevent illegal strike and lockout. In strike and lockout, there is illegal strike is also there, illegal lockout is also there. To prevent that, this act has come. And then to give relief in the matter of when the layoff and retrenchment will be there. In those time, the Industrial Dispute Act will take up this matter, and appropriate measures will be taken up. So to give relief to both to the employer and employee, and then to ensure healthy relation between employer and employee, and moreover there should be a healthy relationship between employer and employee. Employer is the one who appoints the person or who owns the business or manufacturing industry, that is called employer, and the employee, the person who are working in that organization, is called employee. And then industry means well defined organized activity, and charitable institutions is not coming under industry. Then what is industrial dispute? Section 2A defines the industrial dispute. The dismissal of an workman, of an individual workman, deemed as collective dispute. Even a single person is dismissed from the service, that will be taken as the collective dispute, and it will be taken up by the Industrial Dispute Act. Because and another important thing, the non-member of the trade union will not be coming under the Industrial Dispute Act. Only the person who are registered as a member of the union, they can go for Industrial Dispute Act, and they can seek the help of the trade union to proceed Industrial Dispute Act. And then the section 2S defines the workman, that is who are all the employed person should be a skilled person, or even unskilled, or even the manual work will be there, and technical operation, technical involvement will be there, and operational will be there, and supervisorial activity will be there, and clerical activity. These activity, when these activities are available, then it is called industry. Then it is called workman. They are all coming under the workman. And section 18(1) and 2. What is when the dispute comes? When the dismissal of the employee, and discharge of the employee, or retrenchment of the employee, then naturally the industrial dispute will come in handy. And then next we will see these are all with regard to the what is meant by industrial dispute, what is meant by industry, what is meant by dispute, what is meant by workman, and what is meant by the manufacturing industry, or who are all coming under workman. All these things we have seen. Now it will be discussed in another part in detail, but in this video we will take up procedure regarding settlement, adjudication, arbitration. So whenever that industrial dispute exists, there will be the settlement, the dispute will be settled amicably by various redressal mechanisms or grievance mechanisms, They are the settlement, mutual settlement or negotiation, or always called negotiation, and also adjudication. Adjudication means by legal, it will be dealt legally, that's adjudication. And arbitration means by appointing, that is by appointing arbitrators, it will be mutually settled. The problem will be, the dispute will be mutually settled, that is called arbitration, which is coming under section 2p. So these are all the procedure regarding settlement of dispute. The various mechanisms, the grievance settling mechanisms are there, dispute settling mechanisms are there. They are all called mutual settlement or by negotiation, arbitration and adjudication. These are all the mechanisms by which the disputes are settled. First we will see what is in industry. We already told what is in by industry according to section 2a, where there is manufacturing activity and service activity is there, then it is called industry. And the industry will be, there will be an employer which is dealt in section 2g, and workman will be there. By section 2 subsection s deals about the who is workman. And when the dispute between the employer and the employee is dealt in section 2k. So the dispute redressal mechanisms are there, that is mutually, when it is, the dispute is mutually settled between employer and employee, or employer and employer and employee, or between employees, then it is mutually settled, then it is by called negotiation. Negotiation means across the table there will be some understanding will be there, that is called negotiation. So agreement will be reached between the disputing parties, and as per section 18(1), this will be in effect for 6 months. This is the first mechanism for settlement of disputes. Then second, when failed to settle, if the employer and employee dispute is not settled or failed to settle by negotiation, mutual negotiation, then they will go for award by, then they will go for conciliation. Conciliation proceedings will be it is always called mediation. Conciliation officer will be appointed by the government, and it will be notified in the official gazette. Sometimes conciliation committee will also be appointed. One person will be the chairman, and the other members will be from both the parties, that is from employer side and employee side. So this will be published in the official gazette, that is by the government. And then if the conciliation mechanism is settled, it is okay, then the problem is settled. If it is not settled by conciliation officer or conciliation committee, then it will go for arbitration. Arbitration means both parties will be going on mutually agreeing for arbitration. An arbitrator or a member of arbitrators will be appointed, and they will be negotiating with the two parties, and if it is fails, the arbitration fails, as per section 12a, then appropriate government will take up the issue. Then if it is succeeds, then settlement is reached. If the arbitration is succeeds, then settlement is reached between the parties to the dispute as per section 18(3), section 12, subsection 3. Suppose if it fails, the settlement the arbitration also fails, then the appropriate government will take up the issue, and as per section 2a, and that is they will refer the matter to, if does not refer, if the dispute is not referred, then the parties are free to go for lockout, either for lockout or strike. So on the employer side, it is called lockout. They will not allow the employers. They will not allow the employees to get into the work. The employer who appoints the employee will prevent the employees from working into the campus. That is called the lockout. And a strike is the weapon in the hands of the employees, the laborers or workmen. They will, according to section 2(7), they will go for strike. They will sit in strike, pen down strike, and in gate they will be sit in strike. So many strikes are there, and so when the matter is not referred, the parties are free to go either for lockout by the employer side and by the employee side the strike. Then if it is agreed, then it will go for adjudication. Adjudication means according to the court of law. Then it will be the adjudication, the labor dispute will go to the court, labor court, industrial tribunal and national tribunal. So the labor court, the person who is appointed for heading the labor court will be of the judge nature of high court, and it will be published in the official gazette. Then industrial tribunals, suppose if the nature of the dispute is somewhat serious, it will be referred to the tribunal, and if it is of national importance, it will be the central government will appoint the tribunal, and that is called national tribunal. And when the settlement is reached, it will be binding on parties, and if the settlement is not reached, it will be the report will be sent to the government, and it will be intimated to the parties. So award binding for at least 1 year. Suppose if the settlement is reached, award is binding for 1 year. That is according to section 16, 17 subsection A. So the award will be come into effect after 13 days of the promulgation of the award. So this is with regard to the industrial dispute. So in detail we will see the mechanisms, that is redressal dispute redressal mechanisms, that is negotiation, and then conciliation, arbitration and adjudication. These 4 mechanisms will be dealt separately in the next video in detail. தமிழிலே இண்டஸ்ட்ரியல் டிஸ்பியூட் என்பது ஒரு தொழிற்சாலையில் ஏற்படுகின்ற தகராறுக்கு டிஸ்பியூட், இண்டஸ்ட்ரியல் டிஸ்பியூட் என்று பெயர். இது இந்த இண்டஸ்ட்ரி என்றால் என்னென்றால் ஒரு பிஸ்னஸ் ஆக்டிவிட்டி, ஒரு மேனுஃபேக்சரிங் ஆக்டிவிட்டி, அதில் எம்ப்ளாயி ரிலேஷன்ஷிப் இருந்தால் அங்கே அதற்கு இண்டஸ்ட்ரி என்று பெயர். டிஸ்பியூட் என்றால் கான்ஃப்ளிக்ட், ஒரு குழப்பம், ஒரு சின்க்ரோனஸ் இல்லாமல் இருப்பது, அதற்கு கான்ஃப்ளிக்ட் என்று பெயர், அதுக்கு டிஸ்பியூட் என்று பெயர். அந்த டிஸ்பியூட்ல என்னென்ன வருகிறது என்றால், இட் மே பி ஒரு சம்பளம் உயர்வு கேட்கலாம், ப்ரொமோஷன் கேட்கலாம், ரிட்ரெச்மெண்ட்டை எதிர்த்து வாதாடலாம், அல்லது டிஸ்மிஸலை எதிர்த்து வாதாடலாம். தென் வில் சி தி தென் இண்டஸ்ட்ரி என்றால் அங்கே ஒரு கேபிட்டல் இருக்க வேண்டும், இன்வால்வ் இருக்க வேண்டும், ஸ்கில்லு அண்ட் தென் ப்ராஃபிட் இவைகளெல்லாம் இருந்தால் அதற்கு இண்டஸ்ட்ரி என்று பெயர். இந்த ஆக்ட் எதற்காக வந்தது என்றால், ஒரு தொழிற்சாலையிலே ஒரு சுமூகமான உறவை ஏற்படுத்துவதற்கும், டிஸ்பியூட்டை இன்வெஸ்டிகேட் செய்து அதற்கு தீர்வு காண்பதற்கும், அடுத்தது இல்லீகல் ஸ்ட்ரைக்கும் லாக் அவுட்டையும் தடுப்பதற்கும், அடுத்ததாக லே ஆஃப் ரிட்ரெச்மெண்ட் வரும்பொழுது அந்த உரியவர்களுக்கு இழப்பீடு வழங்கவும், அடுத்ததாக ஒரு ஹெல்த் ரிலேஷன்ஷிப், ஒரு சுமூகமான உறவை ஏற்படுத்துவதற்கும், எம்ப்ளாயர் எம்ப்ளாய்க்கு சுமூகமான ஏற்படுத்துவதற்காக இந்த இண்டஸ்ட்ரியல் டிஸ்பியூட் ஆக்ட் நடைமுறைக்கு கொண்டு வரப்பட்டது. இண்டஸ்ட்ரியல் டிஸ்பியூட் என்றால் டிஸ்மிஸல் ஆஃப் அன் ஒர்க்மன், ஈவன் ஒரு ஆள் நீக்கினால் கூட அது இண்டஸ்ட்ரியல் டிஸ்பியூட் என்று எடுத்துக்கொள்ளப்படும். ஆனால் அவர் ட்ரேட் யூனியனிலே மெம்பராக இருக்க வேண்டும். அடுத்ததாக ஒர்க்மேன் என்பவர் செக்ஷன் 2A சொல்லப்படுகிறது. அதாவது கைவேலையை செய்வராக இருக்கலாம், அல்லது ஸ்கில்டு திறமை உள்ளவர், அல்லது டெக்னிக்கல் திறமை உள்ளவர், ஆபரேஷனல் சூப்பரண்டல் கிளர்க், இவர்களெல்லாம் ஒர்க்மேன்லே வருவார்கள். அடுத்ததாக இந்த எதற்கெல்லாம் டிஸ்பியூட் வருகிறது என்றால் டிஸ்மிஸல், ரிட்ரெச்மெண்ட், டிஸ்சார்ஜ்மெண்ட், இதெல்லாம் டிஸ்பியூட்டில் வருகிறது. அடுத்ததாக டிஸ்பியூட்டை தீர்க்கும் மெக்கானிசம் 4 சொல்லப்படுகிறது. ஒன்று பேச்சுவார்த்தை நெகோசியேஷன், இன்னொன்று ஆர்பிட்ரேஷன், அடுத்ததாக கன்சிலியேஷன், கடைசியாக இண்டஸ்ட்ரியல் ட்ரிபுனல் அண்ட் கோர்ட். ஆக இவ்வாறாக இந்த மெக்கானிசம் சொல்லப்படுகிறது.